Good morning, everyone, and welcome to Employee Handbooks 2020, Modifications for COVID-19 Pandemic. I'm Lisa Faganer, Director Member Programs and Services for the New Jersey Business and Industry Association. With us today is Peter Frattarelli of Archer Law. A few housekeeping matters before we get started. Today's webinar is being recorded and will be emailed to you tomorrow along with the PowerPoint for today's presentation, so be on the lookout for those. But if you just can't wait, you can download them right now from the Handouts tab. I'd also like to draw your attention to the Questions tab. Peter would be happy to take your questions, so get them in as soon as they come to you via the Questions chat box. One last thing, it's definitely been getting better, but we've been still noticing some people having audio-visual issues with GoToWebinar platform as they struggle to keep up with all the extra video conferencing going on right now. So if you have any trouble viewing or hearing during this presentation, don't forget you'll automatically be receiving a recording within 24 hours. So if you have to sign out and watch later, you won't miss a thing. Also, this webinar is good for 1 CLE credit, and you can find the link to apply in the Handouts tab. So now, without further ado, Peter, take us away.
Okay. Good morning, everyone. Nice to see you all virtually in some form, some respect. I'm coming to you from my bedroom. As you can see, we are still in lockdown mode, so to speak, at my law firm. So again, very glad to speak with you this morning about this. So let me start on my slideshow. We all good there, Lisa? Is that showing up? Okay.
I still see the partner slide.
Oh. Okay. You don't see my screen right now?
No.
Okay. I'm not sure how to do it. Someone, Lisa, are you the one to, is it Lisa or Jasmine? Give me screen share. Okay.
1 second.
All right. Sorry for the hold up here, everyone. Again, we're going to talk about today while we're just getting this lined up. Yes. All right. While we're getting this set up, what I want to talk about today with respect to your employee handbooks, as everyone who's probably been involved with the Business Industry Association is aware, it just told me it's no longer visible. Anyway, what we've typically done during the course of our years, we've typically had employee handbook presentations, kind of in-person seminars, and often in the form of basically workshops where we've gone through your handbooks, looked at specific clauses. They've been very well received and also, I think, very helpful. Obviously, with the pandemic, we're not able to do that. So I guess you can see it now.
Peter, you good now?
Yeah, you let me know. Does it look good?
Yes, it's good.
All right, perfect. Sorry for the delay.
The internet went out. Sorry.
No problem. Sorry for the delay. As I said, we've done these workshops over the period of time, and they've been very well received. But again, with where we are in today's reality, we don't believe we're going to be able to do these in-person handbook seminars during the rest of this calendar year at least. So what we're planning on doing, in addition to this one, having some 1-hour webinars during the fall, probably one a month, where we're going to go over some of the more traditional employee handbook issues, but and changes, revisions, things like that. But what we thought would be very helpful, at least timely, certainly, would be whether or not employee handbooks need to be modified right now. In other words, in light of what's happened with COVID-19, are there any provisions in your handbooks that need to be tweaked, modified, reviewed because of where we are? And as I'll explain, obviously there's been a whole bunch of changes for employers out there. Certainly, you know, whether it's the FFCRA, the PPP loans we've all done, furloughs, layoffs, recalls. There's been a multitude of issues. But with respect to the employee handbook, what we really want to focus on are which provisions in those handbooks need to be revised or need to be reconsidered now that we've gone through this pandemic, now that we're bringing employees back, or hopefully bringing everyone back. But more importantly, going forward, are there any permanent changes that we think are necessary, kind of in light of the new world we're in? So I want to start with any changes specific to COVID or to a pandemic, but also really on a more fundamental level, what I think should be revised in your handbook as a result of what we've gone through. So let me start, I guess, in the reverse, which is what you probably should not do. And what we certainly don't advise you to do would be to rush out and make changes to your handbook that are really temporary changes. In other words, the laws that we've seen go in effect that are temporary in nature, that we know are related to this pandemic or know are related to COVID. So I'll give you an example. No reason, of course, everyone should know what the FFCRA is. That's the federal law that gave paid leave as a result of COVID, in illness in the family, as a result of someone in the family maybe being sick, school being closed, that type of thing. And it also has the additional 10 weeks of emergency FMLA leave. We certainly don't advise you to go back and change your handbook to modify those. Because generally, we really like to view the handbook. It's certainly not a Bible or a treatise that can never be changed. Obviously, it needs to be updated as laws change, but it also is not something you want to change frequently. Employees like to have a sense of stability, like to have kind of the similar rules, and you don't like to be revising the handbook every time there's one potential change. You can always send out a policy memo or an update if necessary, but constantly changing it, I think, is just a bad idea for continuity purposes, and also, frankly, for when you're trying to make revisions to a handbook. If you're going to go ahead and update a handbook, you have to issue it to everybody. You should certainly make sure you get a new acknowledgement form from the employee that the updated handbook has been received. So again, it becomes an issue of running that down, chasing that down. So again, employee handbook changes should not be done with every kind of change in the wind, so to speak. And also beyond that, I know I had some clients that have an employee handbook which they just update with inserts. For example, it has 80 pages and you tell employees, okay, replace page 70 with new page 70. But you still have the same issue of making sure employees acknowledge it and receive it. So, and making sure that gets run down. So what you never want to be in a situation is if you're ever in court, you're ever in litigation with an employee, and one of the things you want to rely upon are some terms in your handbook. For example, your anti-harassment protections, anti-discrimination protections, accommodation protections. You want to make sure you have proof that every employee got that, and you don't want to have an acknowledgement of a stale handbook or an old handbook. So that's why, again, it relatively don't want to change these with every change in the wind. So all the temporary changes that are related to COVID, I don't see any reason you need to modify your handbook because of those. So, with these temporary laws, as I call them, obviously comply with them. If you have to put up more posters, I kind of feel like everyone's lunchroom was like when we were teenagers and had our rock posters up or movie posters up. That's what our lunchrooms are like anymore. There's just more and more posters. So obviously just keep doing that. That's what the law requires, and that's what we need to do. And that's the primary means of making sure you're in compliance beyond just complying with the law. So certainly comply with all those. But again, I don't see a reason that you need to modify the handbook to get that specific about what's happened in our COVID world. However, as we've talked about, as I started to talk about, as I think we probably all recognize, this crisis has really caused a fundamental shift out there, and I think both employer expectations and employee expectations. We're living in a world where, again, many employers, mine included, a number of us are still working from home. I know my children who are all out of college and working. There's a mix of who's at home and who's not at home. Is again just all the clients we deal with. We have some people back, some people still continue to work from home, and more importantly, you have some specific employees and employee issues where they are allowed to work from home. Maybe it's a COVID issue or an unrelated issue. We've had them working from home, teleworking, or at least partially. We're going to see it, I think, in a significant way this fall. Really, in a month or so, when schools reopen. As we all have heard, if you watch the news, what reopen means, we don't know. Is it going to be virtual? Is it going to be staggered days? We're going to have a number of parents out there that are going to be clamoring. They're going to be clamoring for some revisions to their work hours, to their work schedule, whether they're going to take advantage of the 10 weeks under the FFCRA, if there's a school issue or what have you. So I think we're going to go into the fall with a situation where many more employees are going to need to be able to work from home. And again, whether you have to allow it or not, subject of another seminar, but certainly if it does happen, or you need to allow it legally, or frankly, you have to allow it practically because your businesses need these employees to work and you'd rather have them. We're going to have to deal with that. So my first advice would be to go through your employee handbook, say within the next few weeks or next month, go through your employee handbook and see if there's anything in there that's really outdated or stale. Again, I can't, every employee handbook is certainly not, as we all know, employees handbook run the gamut from very limited to very detailed or very exhaustive. And there's often clauses when I review employer handbooks that don't really need to be in there, but they're in there, and oftentimes employers like to keep them. So if there's anything there that appears outdated or stale in light of where we are and kind of the new normal, I think you should look at that. But really, the main thing I wanted to talk to you about today was I kind of see really 3 or 4 areas where we do believe it's important that handbooks should be will probably likely need to be updated. Again, depending upon the level of detail or the level of information you have, I think they're going to be updated. And that would be in terms of recording time, so your time and attendance policies, the telework or telecommuting world that we, I think, are all in. Even if you have all your employees back, I think it's very important to have something in there that's going to give you that flexibility and set the rules, frankly, for how telework is going to happen. Third, the leave policies, and lastly, in terms of employee health checks, again, I think there's going to be some modifications necessary. And on that last point, as we all know, it was essentially taboo or verboten to consider just testing employees because you were concerned about them being sick. That was always viewed as perceiving someone as being disabled. But as we all know, many employers are now expecting employees to go through a temperature, forehead check or temperature check to make sure they don't have a fever. That is something that normally would not be permitted under the ADA, Americans with Disabilities Act, but guidance has come out and indicated that because COVID has been considered what's called a direct threat, that is permissible. So again, that's something I think we need to go through your handbook and make sure that you're not in a situation where your handbook prohibits it, but you need to do it in order to comply with all the guidance out there and frankly comply with the law and the regulations from both from the state and also the guidance from the CDC. Okay, so time and attendance. The new normal, that was Doug Peterson on there, that was his quote after the Eagles won the Super Bowl. Big Eagles fan. But the new normal means, again, really for many employers, it's either total or partial work from home. But frankly, it creates really a wage and hour nightmare, or it can be a wage and hour nightmare, especially for your non-exempt employees. It's much simpler, of course, with your exempt employees. So your exempt employees who may be working from home, again, I'll talk about that briefly, but it's a little bit less of a concern with them. But certainly with your non-exempt employees, tracking hours, having rules in place are important. And I know that many employers have time and attendance policies in their handbooks, have specific rules, whether it's clocking in, clocking out, lunch breaks, things like that. All those things, I think you have to look and revisit them now. Again, to the extent you have a handbook that's very nondescript on that, you may not really need to make any changes. But if you have a handbook that has those kind of clauses and provisions in there, I think you really need to revisit them for a couple of different reasons. First, remember, a non-exempt employee, and again, what I'll do in a minute is I'm probably just going to briefly do a little primer on time and attendance, just so we know what we're talking about here. But remember, your non-exempt employees who are working from home have to be paid for every hour or every minute they work, right? Because they're non-exempt and they get paid for all time work. So there's 2 issues. One, of course, is how do you track it, and is it just an honor system? And the second, of course, is what are the rules for when they're at home? And again, I think this is something that if you pull up many employer handbooks, it would be like reading Greek as opposed to English, because the rules just really don't seem to wouldn't necessarily apply to employees who would be working from home. So again, let me just briefly, as a little bit of a primer, non-exempt employees, what they get paid for. Again, this is under federal law, under state law. There's no real divergence there. Employees who are not exempt are going to get paid for all hours they're permitted to work or suffered to work. So these are old, archaic terms from the 1930s when the Fair Labor Standards Act was first passed. But what they mean is permitted is the time you want them to work, essentially. So you tell them, I want to work, you're to work an 8-hour day. Here are the hours I expect you to work. And suffered to work is when, and it's not necessarily time we want them to work, but they do it anyway. So as many of you deal with wage and hour know, if an employee works through their lunch break, you know, let's say we're in a normal world and we're back in the office, an employee is given a half-hour lunch break, which is supposed to be unpaid. If they work through that half-hour lunch break without supervisor's approval, they're entitled to be paid for that. They can be disciplined and ultimately fired for breaking your rules or not getting authority, but they are entitled to be paid. But as you can imagine, in the telework era and where we are today, that is going to be harder and harder to figure out what hours they suffered to work. So what hours were they working when they were not supposed to? But again, that's the basic general rule. So things that are on the clock, again, we're talking about in the normal context, and we'll get to telework in a minute, but in the normal context, a break of 20 minutes or less, that's on the clock. Even a larger break than that, where they're not free to go about and do anything, where they're kind of locked in, that can be on the clock work. The changing clothes, you know, again, that may not be as necessary with telework, but they call it donning on or donning off. That's typically paid time. And then cleaning up after the end of the day, that is typically viewed as paid time as well. Other examples, again, these are just some examples: medical attention during work hours at your direction. So send them for a drug test, for example, prep work to do their work, any training that you require them to attend. So in a telework environment, on the job, you know, maybe online training. Waiting around for assignments can be as on the clock work typically. What's not on the clock for your non-exempt employees is absences, vacations, illness, holidays. Commuting time is usually not, unless they're commuting from your place of business to another work site or job location. Changing for their own convenience, jury duty, typically off the clock, unless it's in your contract or your handbook. And then if there's a shutdown of the workplace, obviously that's off the clock. So again, those are kind of just the general rules. I already mentioned meal periods and training as well. The problem is we now got to set the rules for what happens in our new environment, kind of, and really in the telework environment, where employees are not going to be in your office every day. They're going to be working from home, working at a different location than normal. You need to go through and look at what the rules are. So especially if you're non-exempt employees, what you need to do is look at whether your handbook provides first fixed hours. Does your handbook indicate it's 8:30 to 5? Does your handbook indicate, okay, these are the standard hours we expect you to work? Because that may no longer be the case if they're working from home or you have an adjusted schedule. So you want to look at your handbook and see if that needs to be modified. Doesn't mean you need to change that to eliminate it. You can certainly say that 8:30 to 5 is a typical schedule, but add some language in that would say, except for employees who are teleworking, or except, as adjusted. The meal break, again, another great example for a telework environment. Are you really going to have a 30-minute meal break anymore, or 45-minute, or a 1-hour meal break? How is that going to work? So typically what is done is an employee goes to work, they're at their desk, and they're supposed to clock out at the beginning of their lunch break and then clock back in, and they're supposed to either leave or go to the lunchroom and not do any work, right? That's what we've been advising employers for years. But how do you do that when they're working from home? How do you do that when they're working in these offsite locations? Is it even realistic, frankly, to still have an unpaid meal break for an employee who's teleworking? Again, it certainly depends on the nature of your business. If they're working from home, but they're required to be on duty from 8 to 5:30 because they're maybe handling telephone calls or handling help desk, things like that. If it's a rigid set of hours, you can still do it. But if employees, again, for our example, we have administrative staff, our document production people, other staff that we have working from home, they're given specific projects. So at this point, we can have them work 8 hours, but frankly, it doesn't matter which 8 hours as long as it's somewhat towards the middle of the day. So again, you may want to look at your handbook and you need to analyze that meal break provision, your rest period provision, whatever you have, and see if it needs to be modified to reflect the new normal of working from a different location. Also, you have to look at, again, what happens when employees are off duty. Again, if you've been to any wage and hour seminars and spoken to any of your labor counsel over the past 5 to 10 years, we've gone through, kind of a sea change in this. We've really looked at where an employee is working in the office, but when they're home, are they answering emails? Are they sending text messages to their supervisors? Are they handling client phone calls? That's always been a quandary for us, right? So if someone gets a text from their boss at 8:30 at night about I need you to start at 9 tomorrow or something like that, that's going to be viewed as what's called de minimis time. They're not going to get paid for that 30 or 5 or 45 seconds that it takes to respond to a text. But anything broader than that, anything more than a minute or two, where they're answering a client inquiry, they're answering a phone call, then issues come up at the plant or issues come up for the next day, that is typically paid time. So again, whether employees turn it in or not isn't always the story. The story often becomes, if an employee does bring a claim against you, they're going to say, I used to work a half hour, an hour every night, answering emails, responding to phone calls and text messages. I want to be paid for it. Again, you need to look at that because we've had handbook provisions that have been modified over the past 5 or 10 years about that. And those provisions say, you can't work these off hours without supervisor approval. It has to be in writing, except an emergency. Again, you got to look at those again because those may need to be scaled back or at least adjusted for the telework era. Because as I said, if you have someone working from home and you want them to work 8 hours of work, it may not matter as much to you that they're actually available 8 to 4, nothing after 4 and nothing before 8. On the other hand, it may, and that may be something you need to continue. So again, you got to revisit that and see whether any modifications you made in our electronic age need to be backed out. And really, the other issue we have to talk about are timesheets. I mean, how are you going to handle time records for your non-exempt employees who are not always in the office every day? If you have flexible hours, if you have changing hours, and certainly if they're teleworking, how is that going to happen? You can certainly fall back on the old version that we all relied on for years, which were timesheets, where again, you're relying then to some extent on kind of an honor system. But having a time clock system that's going to be on your cell phone where they log in and log off, I mean, that's obviously a terrific solution when they're in the office. But again, when they're out of the office, again, it's going to be a little bit harder to perhaps use that. Again, you can certainly rely on your employees to be honest and to use that. But on the other hand, just in some of the experiences we've had already, employees forget to do it. They think they're at home. They're not always on top of it. Employers look the other way or don't really worry about it, just fill out a general 8-hour day. You just have to make sure that there's nothing in your handbook that is going to be too rigid or too specific that's going to rule out, kind of the new normal that we're in. So I think what's important is if you don't have anything providing for time records or timesheets, it may be important to revisit that. And as I said, the expected hours, the expected workday is something you got to look at as well, since that may need to be modified. But in terms of how you track hours, again, you want to look at what's in your handbook now and see if that has to be revised in light of where we're going. And as I said, I know I said this once, but I think it's very important to repeat this. I think all of us want a vaccine. All of us want this to go away. All of us want us to get back to the new normal. I got to tell you, I don't think we're going to get there for quite a while. And even if we do, I've seen it throughout our client base. I've heard it from other attorneys in my office. We have a lot of clients that are really fundamentally revisiting where they are and what they're going to be doing. And they've been able to go for 4 months having people work from home. Some employees love it, some hate it. I think there's going to be more and more expectation going forward of this flexibility and this ability. So if you don't have anything in there like that, you really ought to consider, and even if you have your employees right now don't specifically need that, I really think it's something you ought to put in place and have available to you. Since, as I said, I think you need to change handbook for other reasons anyway, this is a good time to do it. Remember, most handbooks don't really need to necessarily establish that commute time is not work time. I'll talk about that in terms of a telework agreement in a minute. But one other thing you want to put in your handbook, again, to the extent you have employees who are not working in your office, you may want to give them at least notification that their payroll tax withholdings may change. If you have, I'm coming to you this morning, or is it still morning? I guess it's about right around noon. I'm coming to you this morning from my home in Pennsylvania. My main office that I work out of is in Haddonfield, New Jersey. Pennsylvania and New Jersey have a reciprocal agreement, so it's not a big deal for me. But if you were a Delaware resident working in Delaware for your Jersey employer, if it turns out that you're spending most of your time in Delaware and rarely coming to New Jersey, it may be now you're going to have Delaware withholdings or Delaware payroll taxes taken out. So that might be something you may want to put in your handbook. Notify your employees that to the extent they're going to be working out of state in a telework relationship or teleworker situation, their payroll tax withholdings may change. Okay, I did want to point out, to the extent employers out there in their handbooks have comp time, again, it's something that may need to be looked at because of the telework situation, or because of the flexible hours. Remember, for everyone out there, for private employers, comp time is illegal in many circumstances. And when I refer to comp time, of course, what I'm talking about is somebody works an extra 4 hours on a Tuesday, and they want to have those 4 hours instead of getting time and a half for those 4 hours. I'm sorry, let me back up. They have a 40-hour week. They work 4 extra hours on Tuesday, so that means they're entitled to 4 hours of overtime, which is really 6 hours of their pay. They would prefer not to get that money, but to have that time off later in the future. Unless you're a public or governmental employer, that's not permitted. The only circumstance where it is permitted is if it's in the same pay week. So if somebody works 4 hours extra on Tuesday and your pay week is Sunday to Saturday, on that Thursday or Friday, you could let them work 4 less hours and there's no harm, no foul. What you can't do is carry that over into the following week. That is illegal. And that applies whether you have a 2-week pay period, whether you pay twice a month, what have you. So again, you may want to look, if you do have some type of comp time provision for your exempt employees, that would be different. That's certainly not anything you should change. But if you have comp time, if you're a public employer out there that has comp time, or if there is going to be a situation where you modify it during the pay week and you call it comp time, as I said, I think it's important that you look at those provisions, because again, working from home and working in a different environment may change how that gets applied as well. And okay, so with respect to exempt employees in terms of time and attendance, I don't see a lot of issues there. Again, exempt employees, those who, I know I skipped over this, but obviously exempt employees are those who are exempt from overtime for federal and state law purposes. Non-exempt are those not exempt from overtime. Exempt employees, don't see a lot of issues. The one thing I will tell you is, for exempt employees, we certainly have given advice over the years that I know I have, other firms have as well. If you have exempt employees where it might be a close call, in other words, there's some debate about whether exempt or not, there are a number of employers out there who are keeping time and attendance records on their exempt employees, having them clock in, having them clock out. Just keep that in mind. Remember that if you're going to have an exempt employee who's going to be clocking in, clocking out, keep that in mind going forward, that's something that you need to modify as well. Second topic, and this I've talked a little already about telework, but what I really would advise most clients to do is to include a new telecommuting or telework policy in their handbook. And again, this is whether you have employees who are teleworking now or you're going to need it in the future. Again, I just think it's something that most employers really ought to have in there, because as you'll see, the policy I recommend you include is going to be extremely, extremely employer friendly, extremely discretionary. And I don't think it's going to create any rights or obligations that you have to do it. But I certainly think it's a good time to include one if you don't have one already. So the first question is, do you put this in the employee handbook, or do you then go ahead and have an employee sign the specific telework agreement? My answer is you should have it in your employee handbook no matter what. But the more the more important it is that your confidential information or sensitive information be protected, I think the greater their need is for a signed telework agreement. So in other words, what I'm saying is you should have an employee handbook that explains what the rules are for telecommuting or teleworking. So that way, anyone who teleworks is bound by those rules. And then you can have a separate telework agreement, which will really just parrot what's in your employee handbook, but it'll also maybe have some additional rights or protections, because the most obvious situation would be if an employee is going to be working from home on their home computer and there's highly proprietary, trade secret, sensitive information that they're going to have access to, you may want to have greater rules or requirements about how they log in. Is it a computer that's segregated from the rest of their family? Is it something that's has some additional levels of coding or encryption or protection? I'm sorry, those type of things. So you may want to have additional requirements. And also a telework agreement, the one advantage of a telework agreement is that you can actually make it specific to an employee. So for example, a telework agreement could have everything that's in your handbook, but also have blanks for you to put in, okay, the telework arrangement is from September 1 until December 1. We're going to do it on this basis. Or it's going to actually set maybe more specific hours of employment where they're going to be, things like that. But so again, I see no downside really in having a telework agreement in addition to your employer handbook. But I frankly don't think they're necessary unless you really do have specific confidentiality needs. So again, to be clear, a telework agreement is not a contract of employment. If you have one, it's going to be written to say you're still at will, you don't have any rights, that type of thing. It's really similar to a confidentiality agreement you would have many of your employees, or even a non-compete agreement, for example. When you hire someone, you can have them sign a confidentiality non-compete agreement. Telework agreement would be very similar. But again, I don't really think you need one for many of your employees, since I think you can just go by your handbook. And again, obviously the benefit of a telework agreement is, it gives greater emphasis to employees if they have to sign on to something. And again, it can set out specifics. But on the other hand, I think there's a little bit of a downside to a telework agreement. It's something you have to just administratively have to chase down and make sure they sign it. It can get employees concerned that you're making me sign this new agreement. Why do I need this thing? And as I said, unless you really are putting in enhanced confidentiality terms, things like that, I'm not sure it's necessarily something you have to have. And I don't want to use the word ordinary. That's a bad word to use with your employees. I don't want to say your ordinary run-of-the-mill employee. That's a horrible thing to say. But my sense is that if your employees who are kind of in the similar boat, similar job capacities, that don't have access to really unique information, I'm not sure you necessarily need it, because I do think you can cover it in your handbook, because the telework policy in your handbook, and again, if you have an agreement, would be just parroted over, would give 100% discretion to you as the employer. Again, there's no expectation that the telework relationship will be agreed to, no expectation that it would be continued. The arrangement would be subject to continued evaluation at any time. So even though you've agreed to it, it may be modified, and that would include, reasons why it could change. So it would give you as the employer the ability to terminate this at any time. Again, these are all language you put in your handbook or in your agreement. And again, with respect to that termination, not only can you terminate at any time, but the provisions would indicate why it can end. Business circumstances have changed. Pandemic's over, wonderful. Whatever the reason is, just have a general language that it's going to change we can change it for any reason, but also here's the reasons why. Business circumstances, and particularly failure to follow the rules, failure for an employee to follow along. If you're telling them they need to be available 8 to 4 and they're not, if you're telling them they need to be able to respond to phone calls or inquiries or emails within 5 minutes, 10 minutes, whatever it is, again, I don't think that has to be in your handbook, but certainly the supervisor can set the rules as to what's required. That's going to change by job position, right? So whatever those rules are, if they're not following, that's a reason it may end. Or again, technical or logistical problems. And remember, ending of a telework agreement, because they violated the rules, that might not mean they're coming back to the office. That might mean that they get furloughed again because they weren't able to comply with your telework rules. It doesn't automatically mean now we drag them back into the office, because it may be that we're in a situation health-wise where that can happen. And also technical problems or logistical problems. If there becomes an issue with them being unable to log in and do their work because of those kind of problems, you may want to have the ability to end it. Although again, there you have to be more cautious, because Obviously, if you've provided them with the software, helped set it up, make sure you've done your best to make sure it's working. What we typically do in a telework policy would be to list the reasons or the list of things employers would consider before agreeing to it. Because again, remember, we're in the COVID pandemic world, but if this policy is going to be in there 3 years from now, and hopefully this is all over, you may have, again, in a new normal, you may have situations where you're fine with it for some employees, depending upon, and here's the factors we put in there, what the objectives are, what's the job position, what their past performance has been, including particularly their ability to work independently, right? There's the suitability. Is technology available? Is it accessible? And one important factor, is there a real need for coworker interaction? Is that something that cannot be tolerated? Now, look, it's a harder factor to justify, frankly, in this day and age with Zoom and GoTo, which I guess is what we're using this morning, but that's certainly a factor. And then an expense. Is there an expense associated with this, with maybe us having to set up equipment in their home, things like that? Certainly, we can have exclusions depending upon certain situations. Maybe you can, I've seen some policies, some clients have had us draft a geographic limit. Hey, we're going to allow you to telework if you're within a 50-mile radius, or maybe the opposite, outside the 50-mile radius, whatever you think works for your business. And also, I've seen clients that have only permitted telework, kind of outside of a pandemic or natural disaster, only permitted telework for employees that have been there 1 year, been there 2 years. So they've kind of gone through maybe your initial sort of probationary period. And you also can have the ability to establish the minimum number of days for which they may actually have to be in the office. Again, your handbook wouldn't say what those days are, but you would have that ability to set those rules based upon your supervisor and what's appropriate for that job position. You want to address the expense of the telework. So what's the reimbursement policy? If they're mailing stuff out from home, what are the policies? If there's proprietary technology, obviously you should set that up. And you, again, as I said, you also want to make sure you have the ability, not in the handbook to actually set the specific rules, but to require, say, okay, we're going to be permitted to establish rules for return phone calls, emails, work hours, when you got to be available, what are the core hours. And also what's important is you want to confirm that the call out policy still works, right? I mean, if you give them sick time or you give them personal time and they're not going to work today because they're sick or they're taking personal time, they should call out, let you know that's happening, and not be at 11:30 or 12 p.m. they suddenly tell you, oh, yeah, I didn't answer your email because I was out sick today. I mean, the same rules should apply, and you want to make sure that that's emphasized in your policy. And on the other hand, like I said, if they have run out of sick days and they're just unable to work because they're really sick, I mean, you have to have that ability to enforce that as well. Other things that are in the telework policy, make sure they're responsible for having a secure and safe work environment. Remember, the workplace of someone teleworking really becomes your office or your location. Not in all respects, but certainly in some respects. So obviously you don't have to put up the 38 posters in their home office, but you do have to make sure it's a safe work environment. So if you have any concerns about that, you want to make sure it's secure electronically, but also it's a safe working environment, because certainly in theory, if they trip and fall at home while they're in their home office, they can file a workers' comp claim. There's cases going both ways as to how that would pan out. But I think what's more importantly would be to set rules about coming and going. In other words, if they need to be visiting clients, if clients need to visit them, you really want to have, I think, pretty rigid rules that would either prohibit that or significantly frown on that. Because look, an employee trips and falls at home and files a workers' comp claim, the worst thing that can happen is they file a workers' comp claim and you deal with it. But having someone getting hurt at an employee's home office and filing a negligence claim against you is going to be much bigger potential for liability. So I think you want to make sure that those are pretty rigid rules. And maybe it may be as simple as saying the meetings with visitors have to be electronic or over the computer, by Zoom, by video, or if they have to be in person, that they be at the client's place of work or at your office, and not allow them at their home office. You ought to make it clear their employees are responsible for their own utilities, those type of things. And again, remember, they have to follow all policies while they're at home, including harassment, because as we know, harassment in 2020 happens online more than it does in person. And one thing, a couple other clauses in your telework policy, reminder to employees that this is not a substitute for child care, dependent care. They're not supposed to be the primary caregiver to anybody while they're on the clock. It may seem wonderful that that's why they're doing it to them, but remember that that's not what the purpose of teleworking is. Obviously, if they need to stay home, we're going to be flexible and we're going to work around it. But if you're expecting them to be available between 8 and 4 because of the nature of your business, you need to tell them that that's not a child care or caregiver substitute. And really, if whatever clock-in procedure that you have, you ought to tell them, okay, I am flexible. I'm going to let you work 8 hours from home. If you have things to do with your kids or your family during the day, that's fine, as long as you get your 8 hours in. Make sure that they're told they got to clock in and clock out. So we don't have a clock in at 7 a.m. and then a clock out at 11 p.m. and now you're down the road looking at paying them all a bunch of money for overtime, even though we all know that they were not working those 16 hours. Have an acknowledgement that they have to keep everything confidential. You also make sure you have, at least not in your policy, but some discussion about printing, forwarding, things like that. Remember, if they're using their home computer, there's proprietary information. You want to have the rules in place as to how that's going to both be dealt with while they're working there and how you're going to get that information back when they leave. Okay, couple other things I wanted to cover. One is your leave policies. You know, your FMLA policy, your leave of absence policy, you may want to consider revising them to deal with telework. And again, you're not changing them because of COVID. I'm not saying change it for that reason. But I do think it's important to explain to employees that FMLA and leave of absence policies, sick time policies, again, those apply when you're working from home. So if you're going to include a telework policy, you want to make it clear to the employees that a day off is still a day off. So whether it's, again, as I mentioned before, for a sick day, or whether it's FMLA care, if they need time off to care for someone, if they're recovering from an ailment or an injury, you want to make sure that they're telling you they're applying for FMLA, it's going to be unpaid or they're going to use their paid time. And it's clear that they're not going to work during that time. Again, we're in this new world where we're trying to be flexible and accommodating, but if someone has had back surgery and they're going to be out for 12 weeks, they should apply for FMLA, and it shouldn't be that you know, they get to work an hour or two from home and they think they're going to get paid for the day. Remember, I think that's one tweak or modification when you add a telework policy is you want to look at your FMLA and leave policies and make it clear in there that if you are teleworking, but you're sick, unable to work, generally, then that means you're not going to get paid for the day as a paid employee, but you may have, again, covered under either their sick leave or unpaid FMLA. Okay, you certainly, New Jersey's earned sick leave law was amended earlier this year to indicate that pandemic-related absences are covered by New Jersey earned sick leave. So if you do have a New Jersey earned sick leave specific policy in your handbook, you may want to include the fact that the pandemic related absences. And the reason why I think you have to do that is because the Jersey earned sick leave law was changed to indicate that a COVID fear of return to work or COVID school absences, those are permissible reasons to take Jersey earned sick leave. So for example, someone says, I hear that the bubonic plague is going around and I'm scared to go to work. That's not normally something you can just take sick leave for, right? Because normally you have to show you're sick. But in the Jersey earned sick leave was amended to allow employees who have a fear of coming to work because of COVID, and there really doesn't seem to be any medical tie to that. They just have to have a fear of that. They're entitled to use their Jersey earned sick leave. So if you have your Jersey earned sick leave policy that's in your handbook that gives the reasons why, it needs to be updated to reflect those new reasons. Again, that is, if you had that in your handbook already, you probably have a section that deals with Jersey earned sick leave. And if you remember, it lists the reasons why you can use the sick leave. This was one that was added in there sometime earlier this year. And again, it's already covered this, similar for telework as well. All right, a couple other things I wanted to mention before I'll get to any questions. One is, as I mentioned this at the beginning, many employee handbooks have provisions that deal with drug testing and medical testing. You want to go back and look at that because, again, I can't obviously deal with every possible handbook out there, but I've seen employer handbooks that are really all over the map in terms of what's permissible with drug and alcohol testing, what's permissible with medical testing. So you want to look at that and make sure that you're in compliance. And the specific compliances, you are allowed, as I mentioned at the start, you are allowed to do a temperature check for COVID. You know, whether you can require them to take a COVID test, that's a different story. That, you know, whether someone has been diagnosed with COVID before they return to work, you're going to be permitted to do that. But for just anyone who may have been exposed, it is not permissible to just go ahead and just do widespread COVID testing. But you certainly can do a temperature check. That's permitted by the EEOC. So normally you're not allowed to do any kind of medical exam unless they're a direct threat to themselves or others. But the EEOC has indicated that with where we are, it is a direct threat right now for people. So you are allowed to do temperature checks. So the only reason I'm bringing this up is because there are some policies I've seen out there that are very restrictive in terms of when you can do a drug or medical test. So if you have something in your handbook that says you can do testing in a direct threat situation, then you're fine. But if there seems to be a general prohibition against this, except when you're testing upon cause after an accident, for example, or things like that, you may need to look at that and modify it and indicate that to the extent we're dealing with a pandemic or something in that nature, there may be permissible medical tests. Because frankly, you know, it may not sound like it, but checking someone's temperature is a test, right? That is a medical exam. It's obviously not all that invasive. You know, I was at Lamberti's in South Jersey, and I walked up to the counter to have for dinner reservations sitting outside, and they checked my temperature without me even know it. There was a camera about 20 feet in the air, and it somehow checked my temperature, and I was cleared. So it's not all that invasive, frankly, but again, it is for employers a medical test. So look at your handbook language and make sure you're not in violation there by having that in there. Again, that was what I just mentioned a second ago. And again, also look at your drug testing section, see if there's anything in there that would prohibit you from doing a COVID-19 test upon their return to work. You know, again, there are going to be circumstances where you are allowed to do a COVID test for someone who's tested positive. So again, keep that in mind. If there's something in your handbook that would prohibit you from doing that, just make sure that gets corrected or gets adjusted. And with that, I think I'm a little bit over when I was supposed to go, but with that, I'll turn it over back to Lisa if there are any questions.
Yes, thanks, Peter. That was great. We do have some questions here. That was a lot of good information. But first, let me, the webcam kind of went off, so I'm going to send you this request. See if you click on something, you can get your face back up there while we do the questions.
Okay.
And if not, we'll just go ahead with the questions the way it is.
Let's try that. How's that?
Yep, there you go. Okay, perfect.
I don't know if that helps or hurts, but go ahead.
Well, we'll see. So we do have some questions, so let's see. We have a few minutes. So the first one is, virtual posters are equally acceptable. We have an agency policy folder online and periodically add important info to it and highlight that information during monthly meetings. Is that sufficient?
Yeah, that's fine. The posters, that's permissible by, you can email with an acknowledgement. You can have it in one database. That's acceptable. Yeah.
Okay. The next is virtual agency-wide meetings have always been required. However, we've had issues with EEs not being present once logged. So we've gone to a video requirement, meaning that folks have to be visible. Is that problematic?
I don't think it's problematic. I don't see a reason why you can't do that as a way of enforcing them or testing them. I said, I can't think of a situation where someone's going to say that's somehow a hardship. I think the only issue, obviously, is if there's a technology problem or some reason why it's not working and the employee is unable to access it. You know, there has to be some accommodation or flexibility or ability to work that out.
Okay. Is a telework agreement necessary if employees already sign a confidentiality agreement?
Yes, because, well, no, it's not. I think, like as I said, I think you really only need a telework agreement for that reason. I think that's probably the primary reason. I will tell you though, some clients really do like having a telework agreement because it sets the rules for work hours. It also can set the rules for the work location. So, you know, again, some employees feel just in a more hands-on basis like to have it. But certainly if you have a confidentiality agreement, again, to me, that's the primary reason why you would need a telework agreement. If you already have that in place, I don't think you need a telework agreement. One thing I would tell you, though, is that if you have confidentiality already and you're imposing a telework agreement, you need to make sure that the two are consistent. And the easiest way to do that, again, obviously, is to just say in the telework agreement that this doesn't change whatever else is in the confidentiality agreement. So just make sure it's clear that this is in addition to or a supplement to, and not a replacement of the telework of the confidentiality agreement. The reason being, the telework agreement may end at some point because they come back in the office, and you don't want the confidentiality to end. Whatever you had in there before, you want to make sure it's still in place.
Okay, great. Can you speak to public employment under 18A as it pertains to sick leave, only allowed to be used for the employee versus
Oh, I thought you opened the door.
versus New Jersey, sorry, paid sick leave? Any idea if New Jersey paid sick leave supersedes AAA?
No, unfortunately, I don't know the answer to that. If someone, whoever that was, wants to email you afterwards, one of my partners is more familiar with 18A than I am. I can get back to you. So they want to shoot me an email or chat directly to me on that, I will. I can follow up with an answer. I don't know the answer to that.
Okay. Great, we have a few more. Does every employee's telework agreement have to be the same as all other employees?
No, I think they should all have the same models. So in other words, there's in a number of my slides, I had things on there about employer discretion, about who bore the expenses, those type of things. I think a lot of that model should be in every agreement, but the fact that you would have one employee that may have different expectations or different requirements, I think among job positions, they should be the same. But if you're varying it based upon different job positions, different locations, what have you, that's fine. Again, I don't see there's any issue with having varying versions of this among your workforce. I think among the same job position, I would think it should be very similar.
Okay. For an employer with locations outside of New Jersey, do you advise changing handbooks to comply with New Jersey law for all employees?
That question comes up a lot. In other words, New Jersey, someone just asked about the New Jersey earned sick leave, and that's a really good example. If you provide New Jersey earned sick leave, I have clients that have a general employee handbook for all their locations, and then they have a Jersey section, a Jersey earned sick leave section. So yeah, if you're going to have employees that are going to be working who are going to now be, say, teleworking from a different state, I think you want to make sure that you have yourself covered. So if you have employees who are completely out of state, it often is a good idea not to, because New Jersey earned sick leave is pretty beneficial, frankly. So if you have Philadelphia employees or Delaware employees that you don't want to have that law apply to, I think it is important in your handbook that you segregate and say, okay, for Jersey employees only, this is what you get. I will tell you, it's a really open issue for, say, someone like me who works in Haddonfield every day, but now is working in Pennsylvania. I think it would be probably an uphill battle to argue that I'm not entitled to Jersey earned sick leave, just because I'm working from home now during a pandemic. So I don't know that I could exclude my out-of-state employees who are now out of state only because of a pandemic. Maybe an uphill slog to say we're not still Jersey employees. But generally or otherwise, if you have employees who are going to be working remotely on a permanent basis, or that's how they were hired, I think we can set it up that way where they would not have to follow the Jersey specific laws.
Okay. Do you recommend including in the employee handbook rules about when an employee will be allowed to work from home because of COVID or some other pandemic?
I'm sorry, could you read that again, Lisa? I'm sorry.
Sure. Do you recommend including in the employee handbook rules about when an employee will be allowed to work from home because of COVID or some other pandemic?
I don't. I think it's probably getting too specific. I think if you just say that, again, we're going to list in there the reasons, what the factors are to be considered. But I think it would probably be, I'd be reluctant to include that just because an employee could argue that they'd be somehow entitled to it in the next pandemic, so to speak. So I'm not sure you need to go into that. I think we simply set it up and say that depending upon business circumstances, things like that, this is when telework, may be available. And I think that leaving it that general is probably sufficient to cover this.
Great. I do have another question. Our virtual web conferences deal with sensitive information. So the agency requires EEs to use headsets to facilitate confidentiality. The agency paid for those EEs who indicated a need. Would that be something that should be or could be included in a telework agreement?
Yeah, I think it could. I think you obviously would have to have some out or exclusion, or just be mindful of the potential need to accommodate someone that maybe for disability reasons is unable to use it, which I've seen happen occasionally. But no, I think that is something that could be included in a telework agreement. But I will tell you, that's probably the place to put it as opposed to a handbook, because again, that sounds more job position specific. So, and look, as one other thing I want to point out is, the telework agreement can also be simpler. In other words, you can have a telework policy in your handbook and simply have a telework agreement that has the employee say, I agree to abide by everything laid out in the handbook with respect to telework, cite the section. And in addition, have these 3 or 4 other things that may be job specific. So you can either cut and paste and include it all, or you can make it simple and just say, I agree to abide by the handbook. And in addition, here's the other terms. And that, for example, would be one term that might apply to those employees in that position.
Okay, great. I think that was, let me just check one more time. I think that was the last question that we had. Let me just turn this on 1 minute. Okay. Yep, so that was the last question. So thanks again. Don't forget, all of you will be receiving a recording of today's webinar and the PowerPoint slides via email. And lastly, when you close out of this webinar, a survey will come up on your screen that we hope you will fill out so we can understand best how to provide you important information in the webinar format. Our next webinar is called Returning to the Workplace During COVID-19, and it will take place on August 12th at 11:30 a.m. So by all means, feel free to register for that event at our website at njbia.org/webinars. So until next time, for Peter Frattarelli of Archer Law, this is Lisa Wagner, thanking you for being with us and wishing you a great day.
Thank you, everyone. Have a good day.